Good evening to one and all. Good evening once again. Today's topic is changing dimension in changing dimension of mediation in view of Mediation Act. Today's resource person is our own mediator, coordinator and potential trainer, Srimati Vaishali Hegde, who is going to address all of you. I, I welcome Vaishali Hegde on this occasion. And I request to honor Srimati Vaishali Hegde. So now I request Srimati Vaishali Hegde to address all the participants.
So good evening all, and thank you for making the time to be here today. It is indeed my privilege and pleasure to be addressing and interacting with my mediation family. So thank you. The topic for today is the changing dimension of mediation. And to get started with the before we go in depth into the topic, I thought it's important that we get into the history briefly and then come to how mediation stands today. So, as we all know, mediation is, we know the definition of mediation, we've heard it and learned it several times, but there's some points of in the definition as we were taught and trained about that I would like you to keep in mind. And I would take you back to that at the end of the session as to why I laid stress on it. Now, mediation, we say, is a voluntary process wherein a neutral third party facilitates through dialogue and discussion the disputants to come to a negotiated settlement. Now, what I would like to place stress on is voluntary. Okay? And why so, I will let you know later. This is something, of course, you know, and you know there's a dispute that perhaps leads to litigation, and through communication and negotiation in mediation, there could be perhaps be a closure. So that is what we endeavor in mediation. Now, there are several forms, as you know, of ADR. There is arbitration, conciliation, the Lok Adalat, and mediation. But why are we so, why do we stress so much on mediation, and why do we, I don't say it is the best, but I would definitely say, as on today, it stands on a higher footing than arbitration, especially in our country. Now, why so? One, of course, we pay a lot of attention to the fact that it is about building relations, it is about self-determination, the cost factor, the time factor, the stress that is limited, all this. It is also a matter of, I think, something of absolute importance, that a person very often discovers himself. The disputants very often discover themselves in the course of mediation. That cannot happen in any other adversarial form of dispute resolution, because the very nature of mediation is built on cooperation and trust, and therefore I think as on today, mediation stands on a higher footing than arbitration and the other forms of dispute resolution. Apart from that, of course, the cost factor, which is as of now minimal, next to minimal, the confidentiality, whatever is stated in mediation remains confidential. I would like to place stress on this also. I will come back to the voluntary issue and the confidentiality later towards the end. Why, these are issues perhaps that need to be looked into. Confidentiality, party representation, of course they can represent themselves, they can be represented through their councils. Amiability, it is a very, the entire scenario in a mediation process is very friendly and comfortable. That is what is charming about mediation. Flexibility of the entire process. It is not written on rock or stone as to how a mediation process has to be conducted. Of course, while it is structured, it gives us a lot of flexibility depending on the parties and the dispute that is referred to mediation. So, flexibility, neutral enterprise. So, these are, I think, the main features of mediation which are attractive. Apart from, as I said, we have already dealt with it regarding the cost factor and the adversarial nature being that is missing in mediation, which is attractive, and the fact that since the parties come to in an understanding and therefore they enter into an agreement, it is a win-win situation, so therefore they go back satisfied. As you would see in this, you see the gentleman looking at felicitation, mediation, negotiation and arbitration, while litigation, they say, is like falling into a pit. While, while we are not mediators, we are also lawyers. We would not like to tell this to our clients, but since it's a mediation family today, this is the reality. Once you get into litigation, it is a never-ending circle. No? So, to take you briefly into the history of mediation, let us be very clear. I remember attending a mediating, I am sure a lot of the seniors also attended the mediation, in our Senate Hall in the High Court. When the Americans first came, they had a session for 2-3 days. And I recall one of the honorable judges saying, ಇದೇನು ದೊಡ್ಡ ಇವರು ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಬಂದು ನಮಗೆ ಪಂಚಾಯತಿ ಕಟ್ಟೆಯಲ್ಲಿ ಏನು ಮಾಡ್ತಾರೆ ಅದನ್ನು ನಮಗೆ ಕಲಿಸ್ಬೇಕಾ? We are the authority on this. While so therefore that day of course I was a little disillusioned because I thought I was there to learn something sophisticated, and we were all enthusiastic about the entire process. But now that reality has set in, let us be very clear. Mediation is something that has existed for a long time in the history of mankind. Whether it's in ancient India, of course we love to narrate from what has been told to us that Karna tried to, Lord Krishna tried to negotiate between the Pandavas and the Kauravas. We will not talk about the outcome of it. There are a lot of positives that perhaps came out of that. In ancient Greece, the mediation was used by the city-states in trade and diplomacy, by philosophers like Socrates and Aristotle. Their books talk a lot about mediation. They may not use the term mediation, but the format, and if you talk about the discussion and negotiation, finally what is it they're talking about? They're talking about mediation. Ancient Rome, of course, intercessors who are nothing but mediators were also recognized by law, and family heads often negotiated domestic conflicts. And if you listen to our elders, they'll tell you ever so often how the elders and our grandparents, or the village headmen or the patils as they were called, negotiated settlements in the village level. So this is something that has existed forever. But of course, what we have today is a different form and a more structured form. Now, evolution of mediation in India. Ancient and medieval times, of course, community-based mediation. We have heard of the panchayat system, where the panchayat heads or the council heads or the village headmen used to negotiate the disputes, and what they finally decided was followed by the villagers. But with the advent of the British rule in India, they of course came and introduced the common law and replaced the indigenous dispute resolution system with the formal courts. Now, traditional mediation like the panchayat system declined with the advent of the British rule, and as the legal structure was promoted by the British. Post-independence, of course, there was a revival of the rustic form of mediation, and it commenced with the enactment of the Industrial Dispute Act of 1947, which talks about conciliation, which is nothing but another form of mediation, is what I'd say. At that point of time, please don't look at it from what it is today, you know, where it is very refined and there's a process that has been set in place. But what they actually meant was that an independent person sits and tries to negotiate between the parties and get the parties to a negotiating table and facilitate a resolution between the disputants. The Legal Service Authorities Act, of course, came into force in 1987, which promoted Lok Adalat, which is a people's court. As you all know, there's a sitting judge and representative who is generally presides over the matter. But it is quick, effective, especially in the nature of the cases that are referred to Lok Adalat, like embassy disputes and things like that. And of course, it is another very cost-effective method of dispute resolution. Contemporary mediation, of course, I would say first came into existence with the Roscoe Pound Commission conference, which was held in the United States in 1976. Roscoe Pound is a known legal scholar with a sociological and sociological jurisprudence theory, where he advocated different forms of conflict resolution, not necessarily mediation, but which aligns a lot with the principles of mediation. So that's why it is called the Roscoe, because of his theory, because of his philosophy, it is called the Roscoe Pound Conference, and it is known as the Roscoe Pound theory. Thereafter, in India, our own Justice Malimat's committee report in 1988, the 129th Law Commission report on urban litigation and mediation, recommended that it is time, with the docket explosion, to explore alternative adjudication methods. And this, I would say, led to the, amendment to the Civil Procedure Code in 1998. So I think here we should give a lot of credit to Justice Malimat's committee report, which was, first got us thinking. It also led to the Arbitration and Conciliation Act being enacted in 1996, and thereafter the amendments to the Civil Procedure Code, which brought about Section 89. Now, Section 89, as we know, again, that's the first time that mediation was referred to. And that's when the entire story or saga of mediation in India started. Now, the Salem Bar Association case, of course, has upheld the amendment to the CPC, and the AFCON's case, authored by our own Justice Ravindra, I think just set the motion, mediation into motion. That's what fast-tracked a lot of what mediation is today. Now, mediation in family law, of course, amendments were brought about, and through a lot of judgments, mediation was encouraged, and thereafter in commercial mediation, company and businesses began adopting mediation to resolve their disputes for contract enforcement, and in JVCs, joint venture development agreements and things like that. Thereafter, of course, there is the 2019 Consumer Protection Act, which has very clearly said that mediation should be used as an official mechanism to resolve disputes. Arbitration Conciliation Act we have dealt with, that was 1996. Now we come to our very own Mediation Act of 2023, which is a landmark legislation, I would say, because it has finally given teeth and recognition to mediation. And it provides a comprehensive framework for mediation in India. Of course, it's besides the point that it has not come into force in full, but when it does, believe you me, I think we have a career in mediation that we can take seriously. Now, with of course Mediation Act and things like that, before I come to online, ODR mechanism, I would say that COVID-19 changed not only our lives, the lives of everyone in the world. For once, the world was one, because we were all affected by it, and tough times, I think, brings about drastic reactions, and it's wonderful to see how the human reacts and resolves to sustain themselves in these difficult times. And in no time, you saw online litigations and set up in courts, online mediation. I remember, I think a few of our friends also used to come here during COVID. It used to be, they used to not even open this part. It was all closed. It was only for the rats to scamper around. Just those 2-3 rooms were open, and there were hardly, maybe 1 or 2 of the parties used to come. It used to be only online. And until then, I at least had not done any online mediation, and it was really enlightening. It was for the first time you're connecting with people. I remember I had a partition suit, some house in Gandhinagar, 4 sisters, 1 sister in Gandhinagar, she was refusing to, cede to the partition. So these other 3 sisters, one in Australia, Canada, and I don't know where else, and they would be in their 90s, because to the different time of the year, one would be dressed formally, one would be 90, also casual, but there was a binding and a bonding that happened during mediation, which was, during COVID, which I think really changed our outlook. So with COVID, I think the use of technology is something that developed in a large way, and that's when I would say that ODR, or online dispute resolution, really took off. It is, of course, as you all know, it's a digital mechanism where we use technology, that screen distracts me every now and then. Okay, use technology even in mediation and in litigation, arbitration and negotiation. It is also used widely in e-commerce, financial disputes and corporate conflicts. And this, of course, thereafter, with Section 30 of the Mediation Act, provides for online mediation, and now we are doing it regularly, as we all know. The Mediation Act also talks about private mediations, where private mediation centers have been given, a recognition. There are so many centers in Bangalore, and once this act comes into force in full, we all can think of, something other than a lawyer's board, a private mediation, being what stands under our name quite proudly. So it allows parties to tailor the process to the needs of the parties and gives them great flexibility. I'm sure all of you must be doing a lot of mediation. For those of you who handle family matters, I know that first you all will always try to mediate and try to get the parties together, or whatever it is, to reconsider their decision. So this must be something you've done in the past. But now, with private mediation getting recognition through the Act, you will have to do it, perhaps be a little more careful and do it in a more structured and tailored fashion. In fact, there's a format that has to be followed, and their consent has to be taken in writing and things like that. So these are things that we will adapt in days to come. International mediation, of course, India is a signatory to the Singapore Convention on Mediation of 2019, where it seeks to recognize and enforce international mediated settlements. Okay? The aim is to promote mediation as a reliable dispute resolution method. So the rest I will give it a skip. Now, mediation in Indian statutes. See, this is something that was, conciliation was there, arbitration was there. Mediation was not there. Now, if you see, of course, the Industrial Dispute Act 1997 talks about labor dispute mediation, but they are actually talking about a conciliator who gets the, parties to conciliate, and he acts as to negotiate their differences, and as a conciliator, he gives his views on the point, and thereafter disputes are settled or whatever it is. Now, Section 4 of the Industrial Dispute Act provides for mediation by conciliation officer to resolve an employer-employee dispute before going to the labor court. The conciliation officers, as you all know, are appointed by the government for mediating and promoting settlement. These officers may be appointed for specific industrial dispute or specific areas. Now, please note, they are government appointed officers. Okay? Now, the legal service authorities, as we said, the Lok Adalat, it's a non-adversarial dispute resolution. Agreements reached in Lok Adalats are binding and enforceable. Again, I would say the the authority is a sitting judicial officer and either a lawyer of standing, whatever it is. So free expression of one's opinion or ideas may be difficult in Lok Adalat. As you'd see, before a judicial officer, it would be difficult. So the nature of matters to be settled before the Lok Adalat will be limited. Arbitration and Conciliation Act, of course, Section 30 of the Arbitration Conciliation Act 1996 promotes settlement of disputes through alternative means. There's an arbitral tribunal. As you know, that now very often matters which are referred to arbitration, if they feel that is not something that is being resolved through arbitration, they are referring those matters to mediation. So they are, this is a new concept that has come into use, where arbitration and mediation are used to settle different issues in the same dispute. Or it could be the same issue wherein they feel that, okay, this is more suited for mediation rather than arbitration. So they send it to mediation. If it settles, fine. If it doesn't settle, it goes back to arbitration. Okay? The same way, even in mediation, there may be certain cases, like recently there was a matter between the building, the residents of the building and the builder. Now, while mediation is going on, I think if it doesn't work out, that I would definitely suggest that they go to an arbitrator rather than go back to court, because they've been in court already for 14 years. So it is about, OC and the e-kata and the usual, the regular things that happen between a builder and a thing. So we are trying out things in mediation, but if they don't come to terms, I would definitely suggest they go to arbitration, somewhere, some arbitrator who's acceptable to them, and settle the matter there. Now, Part 3 of the Arbitration Conciliation Act, of course, deals with conciliation. But what is really interesting is, if you, I'll take you to the new act. The new act does not talk about conciliation at all. The new Mediation Act has practically done away with conciliation. So please understand that when you are talking about arbitration and conciliation, from now on, you can quite confidently say it is arbitration and mediation. Maybe in labor matters, conciliation would still be there because he's appointed by the government. But everywhere else, conciliation would perhaps have to be replaced with mediation. Now, the game changer, as I said, was first the amendment to the CPC with Section 89 being introduced. And Section 89, as you know, deals with alternative dispute resolution, wherein it states, if a court finds an element of settlement, it may refer the matter to ADR before proceeding with, it may. At least CPC says may, okay? And agreements are reached, so therefore there is still a sense of consent of the parties is still, factored into it in the CPC. But as we go forward, you will see how the may has changed. Now, family courts. Family court under Section 9, courts must encourage parties to resolve their dispute through mediation before litigation. Here also they talk about must encourage. So it is, you cajole the party, you ask them, you tell them. Now, MSME's Development Act, Section 18 of the Act allows either party of the dispute to make a reference to the Felicitation Council, and it's open for the council to refer the matter to either arbitration or any of the ADR. So now you can see how slowly the entire process of mediation has got into different spheres. Before it was restricted to family disputes, now MSMEs, thereafter your Companies Act. 444 allows mediation and conciliation even in matters which are pending before the NCLT. So even winding up and things like that, if there is a possibility of a settlement, the NCLT can refer the matter to mediation. The Mediation and Conciliation Panel has been established again by the Ministry of Corporate Affairs, okay, to settle. Now, RERA, as you know, Real Estate Regulation and Development Act of 2016, the Section 32G of the RERA Act conceives of resolution of disputes between promoters and allottees through conciliation. As I said, conciliation, what is conceived, what they are talking about is nothing but mediation now, because the new Mediation Act has done away with the term conciliation, and they've said very clearly, wherever it is referred to as conciliation, it will be replaced with mediation. The objective is the Karnataka RERA Conciliation and Dispute Resolution has been established to facilitate resolution as amicably as possible by referring it to the Real Estate Regulatory Authority or the adjudicating. As you can see, the number of disputes pending in the consumer forum between the developers and purchasers, I think this is a welcome step. The Consumer Protection Act, so many of us here are in the Consumer Forum panel. Chapter 5 of the Consumer Protection Act that has been introduced talks about mediation in consumer dispute. I think nothing is more favorable because people are troubled enough. They don't need to spend more time being harassed in the various consumer forums and then finally in the Supreme Court. It's best they negotiate their disputes and close it as in the mediation forum. Now the Mediation Act of 2023, I think my respected sir here, Justice Shivkumar, would defer with the term landmark legislation. He is a staunch critic of the act, but today I'm here to talk positively because I believe we should look at the positive. It's a start, and tomorrow, okay, any changes that have to be made will be made along the way. So the Mediation Act of 2023 is a comprehensive law in India which is dedicated solely to mediation. It provides a structured framework for mediation in India. Now, the main key provisions of the Act is that it establishes pre-litigation mediation as mandatory in certain civil and commercial disputes. Now, we have been told several times that mediation is voluntary. Now, if it is mandatory, how can it be voluntary? And if it is voluntary, how can it be mandatory? Aren't the two contradictory is what I say. Yes, ma'am. Yes, insert in. Now I will take you to others. This term mandatory is being used in quite a few. Uh, mo- yes, yes.
No, no.
And then if the Honorable Judicial Officer says, then it will be, voluntariness will automatically come about.
No, it's voluntary to come in. It's not, mandatory to come in for mediation. It's not mandatory to settle your dispute.
No.
Exactly.
That is true. But the fact remains, whatever we taught, we said that even going for mediation was voluntary. Now please understand, that part of it has gone.
That part.
That part of it has gone. Mediation is here to stay. It is at your doorstep. Yeah? So whether it is this act or thereafter, I will take you to the various act where it has become mandatory. So it is mandatory in certain civil and commercial disputes, and it ensures that mediated settlements are legally binding. Now see, this is what I found was the most attractive part of this legislation, because there were a lot of people who were quite willing to settle their disputes. You know, during the course of these 16 years that I've been in mediation, at least the last 10 years, the mindset of the people, especially the younger generation in the urban centers, has changed. They want a quick fix solution and they know exactly what they want. But the enforceability of any agreement in a private mediation is something that they were not convinced about at all. And whatever it is that we used to say, I felt there was always an element of doubt. So the teeth that arbitration had was missing in mediation, and I am so glad that, subject to what Sir has to say, that this Mediation Act has come into force in whatever manner. Thereafter, we hope that in the years to come, whatever tweaks and changes have to be made will be made. Now, it recognizes institutional mediation and online mediation. See, in India especially, I have noticed that when there is a written law, adherence to it and acceptance of it is much stronger. We need everything written. Elli bardidare? Right and illa, sir. Ellide, board ellide. We have to be told. Everything is like that. The moment it's written, we will accept it. Yeah, we may accept it. Those who want to accept it, those who don't will not. But even it's not a written law, you know, people always thought, oh, mediation. That is what it was. In fact, even I as a mediator, I spent a lot of time with a lot of people, convincing them, and convincing them that I'm doing real work. You know, it's not that I'm just sitting and listening to people's sad stories every Saturday from morning to evening. But now with the Mediation Act, I can proudly say that, hello, there is a legislation which gives us teeth, and it is binding. So I feel that is, a welcome step. And it provides, of course, framework for the Mediation Council of India to regulate the mediators. This word regulate is a little troubling, but I don't know who's going to regulate us. But anyway, once the Mediation Council comes into existence, we'll see. Now, why I'm happy that the Mediation Act has come into force is for this reason. I feel it was a totally underappreciated form of dispute resolution. You know, in fact, even in the courts, mediator, and you know, recently there was ADR week in Bangalore, where all the top firms and everyone was there. And for once I saw that at least half the sitting judges of the Honorable High Court and the Supreme Court, who were speakers there, spoke more positively of mediation than of arbitration. In fact, there were a couple of the honorable judges who went to the extent of saying arbitration has failed in India. It is nothing but another form of, what do you say? No, forget about adjudication. They were very, very critical about how expensive it was and how it was just not expensive and it was time consuming. And there were several judges who took the podium who stated that it is mediation that is the ADR of tomorrow, and that is the most suited form of dispute resolution in India. And for once I saw that the arbitrators who generally walk like this and the mediators who used to walk like this, it was a different scenario. I tell you it was. Because everyone was talking so positively about mediation. By the end of the week, I felt that, wow, we have come out, We obviously, see, we have a lot of credit to take, all of us. Let me make it very clear. It is because of the results that we have shown that, they can talk about mediation so positively, but it gave me a lot of hope. But until recently, and maybe even now, but not in the days to come, mediation was an undervalued form of ADR, but it has huge potential, especially in India, I feel, because it's cost effective. And in the commercial sector, we have seen great results. An increased awareness and stronger legal backing with the introduction of the Mediation Act, I think the potential for it to grow is great. So mediators, chin up. I think we have a career after retirement from litigation set in motion. Now, as you know, you get into litigation, it is a maze that you never come out of. Mediation, you can meet halfway and find a solution. So this is obviously the positive of mediation. Now, as I said, post the pandemic, there's a resurgence of mediation because, it's important sometimes to tell you all anecdotes. There were 3 or 4 couples who came, during the pandemic. And there was a lot of time to talk to them. They had time, we had time. They were also working from home. And I told them all that, see, now this difficult time is going on. The courts are also not functioning. Why don't you use this time to build this relationship, whatever difficulties you have, etc., etc. The usual pep talk, all this. Believe you me, all 4 couples came back immediately after I remember June 2023, from January to June, all 4 couples came, in different times.
Participant mic unmute ಮಾಡಿದ್ದಾರೆ mute ಮಾಡಕ್ಕೆ.
Someone has put on the mic, I believe. ನೀವೇ ತಿಳಿಸಿ. I think someone has switched on the mic. Could you please switch it off?
We request all the participants to mute your mics.
Okay. And all of them came back. And I said, wow, you all are together. Isn't it wonderful? So you all have, reconciled. I said, no. This COVID has made us realize that we certainly don't want to live together. Life is short, time is limited, there's no time to waste. The only thing that we have decided is, earlier it was I who wanted to file the divorce. Now we have mutually agreed that we will part ways. So, so now it's a quick fix, generation. As you know, it's a cappuccino generation. They call themselves Gen Z. I'm still trying to figure out what Gen Z talks about, as you know. Now they're not even getting married. They don't have children. Yes. No, if they don't get married, I have no problem. That's okay. You live in peace. Someone else somewhere is living in peace. But the lack of patience once you get into a relationship is something that I find difficult to stomach. But that's what they did during COVID, by the way. So the pandemic made us realize that time is limited, that we better, fix us, find solutions to our problems. And therefore, what better way than mediation? So, we have this ingenious way of filing solutions in very difficult times. Now, as you know, in the Indian context, we do not have to talk about the docket explosion. Our honorable judges are here. They should know the stress they are under. I believe, just recently there was a comment about an Uttar Pradesh judge who had some 15,000 cases pending before him, and he said, how am I supposed to deal with this? And his Lordship Justice Ravindra has written an article where he talks about, I would request you all to read that article, it's so beautifully written, 5 crore cases, and he says if you don't see the writing on the wall now, we will never see it. So we better smell the coffee. We have smelt it. We should make others understand that mediation is here to stay, and the best way to settle disputes is through this non-adversarial process. Now, the objective of the Mediation Act, of course, is to promote and facilitate mediation, especially institutional mediation. So all those who are, a little early off the block and have set up institutions where private mediation is available, good for them. Now it will take off in a big way. To encourage community mediation, I believe, I was just asking sir, he, I think, did the first community mediation in Bangalore Mediation, Karnataka Mediation Center. He tells me that there were over 300 participants, and it was quite, though there were 3 mediators, that's another thing. They say that should be 3 mediators for every community mediation. But, whether it would be possible in a center like, in a center, or rather that we go down to the community, is something that, we will have to evolve in times to come. Rather than make 300 people come to the center, it would be better that we reach out to them, by organizing workshops or whatever it is. Anyway, but it has been set in motion. The key feature, of course, is the voluntary option of the parties to mediate. As Madam Menon says, to mediate is an option, but to get to first take the first step of going into mediation is not an option. Where, as you know, in the Commercial Courts Act, setting up requirements of mediated agreements, in an agreement can be now endorsed by the Mediation Council, and once that is done, it is enforceable like any other order from the court. Unless there's exceptional circumstances where interim orders are required, commercial courts and things like that will refer matters to mediation. So that is upholding the parties' autonomy, all that is required in what we have been trained in, that is still there, autonomy, and gives the right to adopt a right to the parties to select their mediators. They can go to the service provider. A service provider can be a private service provider or an institution of the government like the KMC. Framework to prevent conflict of interest, and providing of disclosure requirements and obligating mediator to be independent, neutral and impartial. All these are standard requirements. Setting up of the Mediation Council is something that we are looking forward to, because once that is done, we can take our mediations, private mediations forward. List of disputes, as you know, what has been added, I would say, is land acquisition. I remember Sir mentioned in his talk, which he addressed, I think, a month ago, about contempt cases being referred to mediation. And I was saying, why not? And I will still say, why not? Because I know contempt is supposed to be when you offend the court. It is between the court and the party, the accused. But I think the time has come, and our Indian courts are just too mature to be offended by these sort of things. They are too large to be bothered. So they know that I am not going to be offended by this. This is something that can be resolved by 2 parties. It has been brought to my notice merely to, so that I act as executor. So the honorable courts have got more than enough work to do. They are neither offended, and it's best they refer such matters to mediation. I think all my friends here would have dealt with quite a few of the contempt matters. They're being referred regularly. Land acquisition matters are being referred to mediation. Even PTCL matters are being referred. See, all these are extremely welcome. Another thing I find a welcome step is the 180 days limitation, because what happens is 60 days is just too little sometimes. In cases where they are not interested, it's different. But in cases where they really want to solve the matter, it's just too little, and every 2 minutes, every 2 months going to the court and getting this extension breaks that continuity. Now, so often they want to get their release deed, gift deed, wills registered before they report the settlement to court. Now, this e-Khata issue has been going on for 3 months. I had to send 3 matters back because they could not execute their release deed because they didn't get the e-Khata done. So, which is really frustrating because we all put in a lot of effort to get, it's not the agreement that matters, but the fact remains that once you have put in that effort and the parties have come to that stage, you'd rather see them settle it rather, than send it back to court. So, of course, the grounds of challenge are limited. Community mediation, as I said, we have dealt with it. Extending application of international mediations conducted in India. Okay. Now, this is something that is a little tricky because, not fit for mediation, we are all aware of it. I don't have to go through it, criminal and all this, and applicability. Involving domestic parties. This is what? Involving at least one foreign party and relating to a commercial dispute. But it should be conducted in India. If mediation agreement states that mediation will be as per the Act, that also should be stated. Now, what is the difficulty is that, 180 days, the parties, mediators appointed by the parties and the service provider, mediator will disclose any conflict of interest. All this we have been have gone through in our training process. Now, I will go straight to the difficulties, key concerns of the Mediation Act. Now, 1, it mandates pre-litigation mediation.
Sunil?
As I said, the voluntariness is compromised. According to the Act, pre-litigation mediation is mandatory for both parties filing the suit and for proceedings proceedings in a court. Now, under Section 21, we may say that this could be challenged, saying that it's my right to decide whether I want to go to mediation or not. I don't want to subject myself to mediation at all. Okay. Now, multiple registration needed for mediators. Okay. Mediators have to be registered and empaneled at all 4 places. Mediation Council, empaneled by the court, annex mediation like we are, a recognized mediation service provider, or legal service authority. Now, that makes it complicated. So, it's like registering ourselves. But I think once it comes into force, it will fall into place. That's what I hope. It is unclear why we have to satisfy all 4 of these conditions and just one is not enough. Then this government intervention is always a matter of concern. Central government approving before issuing regulations. Under the Act, the Mediation Council will discharge its major functions by issuing regulations. So, now it is going to be government regulations. It must take approval from the central government before issuing such regulations. Now, we know it is, the mind of each government changes, so we'll have to keep, adapting to that. So, that may be difficult. Mediation Council's effectiveness could be limited as it requires the central government's approval for its core functioning. So, and this is, not required either by the Medical Council of India or the Bar Council. So, then why should the mediators be governed by the central government is something that needs some thinking. Let us see. Then full-time members of the council must possess knowledge and experience of mediation and ADR and mechanisms. They don't necessarily have to be practicing mediators. Of course, my first objection is the definition of mediation under the Act, and a mediator under the Act. Anyone can be a mediator. Then why are we undergoing these trainings? So that is something that will, of course, have to be looked into at a later point of time. It's running. Am I running short of time? Is that why it's running? So, then of course there are all the landmark cases. We know of the AFCON's case. If you all have not read it, please do read it. Then AFCON's case, of course, sir, ನೀವು ಇದು ಹೆಂಗೆ? ಲಾಸ್ಟ್ಗೆ ಹೋಗಿ, last. The end, I don't, because there is 10 minutes, I want interaction at least for 2 minutes. Till I get my slides right, is there anything that you all would like to say? Yes, please. Or Mike.
Mike.
No, next. ಇರಿ ಒಂದು ಹಿಂದೆ ಬನ್ನಿ. ಬರ್ತಾ ಇಲ್ಲ, ಅದೇ ಮುಂದೆನೇ ಹೋಗ್ತದೆ.
So because it's recording, so I wanted the mic. Now, once the mediator gets registered under this act, is there any mechanism how the mediator will have both the parties to come? Like how does the case come to the mediator? Is there anything in the act?
See, I think there is a format that they are going to be. I think the regulations and the rules will have to come in, all that will have to be done.
One party is interested. So how will the other party, how are we going to get them? For pre-litigation, now we are asking the services authority to send a notice. Correct. So somebody who sees a notice from a public authority may think of coming. But for private person, how are we going to do
Now you
that?
are talking about in private mediation or
When
for
we-
CMC?
No, private mediation. You spoke about Mediation Act, right?
Yes.
So under that.
Private mediation, what are we doing now? I think we'll have to send a notice like we do in any other case.
That's why Mr. Shivkumar says it's ineffective.
Sir?
So under the regulations, we are going to get methods in which we can send notices to the other side. Oh,
And there's
okay.
going to be a format which even the mediator will have to sign. You know, confidentiality and
of
all
course.
that.
That's okay.
Everything is there. There'll be a format.
Having the other side to come.
So it's going to be extremely,
So one more, no, I must appreciate the lovely slides that have been made. Very
so
nice.
sweet.
Very,
So
very
sweet.
nice. Thank you.
So sweet, thank you. Yes, ma'am.
You mentioned that mediators under this act, no?
Yes.
If you are registered with the mediation council, you have to be registered with all. I think I differ.
I think there is, see, actually, I did not, when I
I
read
think
the...
Shiv Kumar sir will throw light on
Yes.
this. Yeah, under the act, yes. Yes. No, what I want to ask is, suppose I am a part of a court annex mediation, do I again have to, like all of us are part of Karnataka KMC, do we separately register with MCI?
Yes.
Yes. Exempted from. Okay,
Or
thank you. Bangalore, okay, thanks. I had a doubt about that. Actually.
Yes, there's no clarity as such.
It's slightly confusing.
I was a little bit, you know,
And if nobody has a question, I have something to ask.
yes.
So now we have 60 days. There's a problem that we are facing. I think I also request the director and the coordinators also for attention. Now the case goes back. Sometimes the parties come back to say there's a small, we want to tweak our agreement.
Correct.
So we want the file referred. The court is not able to refer because so much of stress in the court for the parties to come back. So what options do we have?
Yes, we really need to...
What do we do with this? Can we just have a small 5 minutes? I had one suggestion, whether the director's office can request the registrar's office in the High Court to re-refer the matter. Only those which are referred.
Yes, which are at that stage.
Huh?
See, it is for the court to agree the agreement which is enforceable in law, if there is any changes the court thinks, the court can modify the agreement with the consent of parties. You can change it in the court itself. Re-reference is not required. Court ಮಾಡಬಹುದು. It will take some time. You have to- Yeah, yes.
Actually, it is, the party should actually bring,
Register ಮಾಡಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅದು. Reference is a court order, individual court.
because so many of them are getting spoiled like this. Yes, sir. Sit down, sir. Yes, I'm coming to that, sir. 2 minutes. 1 second. No. My slides went. No, this is the best part of everything, actually. Of course, undefined terminology, exceptional circumstances. Again, it will be left to the, discretion. This exceptional circumstances, that is in the Act. So then, of course, Niti Aayog has said that it is not available, our internet is not available. As you know, we suffer this every day. So very often while we are arguing the cases online in court, there's only one half of the argument that is heard. And therefore, then we'll tell the Honorable Judge that, no, we'll come to court and argue the matter. So these are issues that, we face. These are teething problems. As I said, the AFCON's case, which you have to look into. I think it's a landmark judgment. It deals Salem Bar Association, Srinivas Rao and Deepa. There are a series of these cases that I would request you all to, when you all have the time, you all must have gone through it. But since I'm standing here today, I have to tell you all to do this. But I think this now is, the Karnataka Amendment Bill of 2024, which has been introduced, which makes pre-litigation mediation or pre-institution mediation for all civil cases mandatory unless there is exceptional circumstances where they want urgent relief. So you can imagine all civil matters will first, like every commercial dispute, will have to be referred to mediation unless there is urgent relief. So if this comes, you can imagine, I think we'll have to hang up our black coats and wear our beige coats. Can you imagine the number of civil litigations will be referred? Why, sir? That is something that we'll have to fight for, that Bangalore litigation. That is not correct. It will have to be through the, if our honorable sirs are willing to take on the additional burden, then we will have to fight and get it referred.
No, cannot the Legal Service Authority give it to them? They don't have any machinery. It's notified, I agree. We have to take it up. Can we not file any objections or reply to this, to the Parliament? No?
No, they've submitted it. Yes, it's a bill. Yes.
Can we not file objections to that then? Okay. Start preparing.
So just like the Commercial Courts Act, this will happen, and I think that will be, keep us all busy. Thank you. I think I've just finished on time. Thank you so much. Are there any questions that, 2 minutes questions, any questions that you all would like to ask, or your own inputs? See, this is an interaction. There's nothing that I am saying that you all do not know already or are not highlighting. So if there's something that you all would like to.
I request participants from Dharwad and Kalburgi units as well, respected mediators who have joined us for today's CME from there, they also can put forward their query if any. Am I audible to them, I believe?
Yes, you are audible. Excuse me, madam.
Yes, sir.
May I put a question? Madam, I am M.H. Patil, a mediator from Dharwad bench.
Namaskara, sir.
ನಮಸ್ಕಾರ. ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಒಂದು ಪಾರ್ಟಿಷನ್ ಸೂಟು RFA, once it is referred for me for mediation, ಫಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೇ ಅವರು 2 ಪಾರ್ಟಿ ಬಂದಿದ್ದು, ಅವ್ರ ಲಾಯರ್ ಬಂದಿದ್ದು. ನಾನು 3-4 ಸರಿ ಅಡ್ಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ರು, ಅವ್ರಿಗೆಲ್ಲ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಬರಲೇ ಇಲ್ಲ ಅವರು. ಅನಿವಾರ್ಯವಾಗಿ ನಾವು ರೆಫರ್ ಬ್ಯಾಕ್ ಮಾಡಿದ್ವಿ. ಮತ್ತೊಂದು ಸರಿ ಅದನ್ನು ರೆಫರ್ ಮಾಡಿಸ್ಕೊಂಡು ಬಂದರು. ಬಂದ ಮೇಲೆ ಎಟ್ ಎನಿ ಕಾಸ್ಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಎಂಟೆಡ್ ದಿ mediation, either appellant or respondent or their counsels. ಅದಕ್ಕೆ ಅವರು ಐ ಥಿಂಕ್ this had to be avoided.
Yes, sir, there are two, I think in our trainings, we have given those two judgments of the Honorable High Court, wherein costs can be imposed on the,
Yes.
erring parties. That's the best. It's nothing that the mediator can do. We are here to facilitate a voluntary process of negotiation, but the judicial officer can definitely take note of it and impose cost on the parties, so that they do not, indulge in this kind of behavior. Thank you,
Yes.
sir, if I have understood.
Yes, S.L. Matti from Dharwad.
Namaskara, sir.
Madam,
Yes, sir.
ನಾನು ಮೀಡಿಯೇಷನ್ ಮಾಡೋದ್ನಾಗ ಒಂದು ಪ್ರಾಬ್ಲಮ್ ಕ್ರಿಯೇಟ್ ಆಯ್ತು. ಒಂದು ಪಾರ್ಟಿ ಇದ್ದಂತವ ನಾನು ಎಂಟೈರ್ ಮೀಡಿಯೇಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದ.
Oh,
ಆಗ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ನಾನು ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿಸಿ ನಾನು ಅದರಿಂದ ರಿಟೈರ್ಡ್ ಆದೆ. ಕೇಸ್ನಿಂದ ಬೇರೆದವರು ಹೊಡ್ಸಿದ್ರು. ಅವಾಗ ನಾ ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು? ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದಾಗಿತ್ತಾ ಅಥವಾ ಬಿಡ್ಬೋದಾಗಿತ್ತಾ ಅದನ್ನೇ?
sir, adike, because there are all these ingenious parties, now tilstivi that you keep your phone switched off on the table. But in spite of that, if they still indulge in this kind of behavior, there's nothing much we can do. They cannot use what is recorded in any of the proceedings. That is the only thing that is heartening. More than that, there's nothing we can do, because if they keep one phone, there may be another phone in the pocket.
Yes,
Estanta now,
yes,
there's just that much we can enforce these kind of these ground rules. So it is not on you, sir, it is on the party. Now ಎಷ್ಟು ಮಾಡಬೇಕಾಗ್ತದೆ ಮಾಡ್ತೀವಿ, ಅದರಿಂದ then you should leave it.
ಅಲ್ಲದ್ರೆ ನಾನು ರಿಟೈರ್ಡ್ ಆದ ಕೇಸ್ನಿಂದ.
ಅದೇ, okay, sir.
Oh, thank you.
Yes, sir.
I am
Mike.
from Gulbarga. We will refer them back to the court on all the referred matters, madam. But the court cannot impose any cost because you are not mentioning anything about they are absent or no anything. But how can impose the cost?
No, sir, I cannot be talking about what judicial officers should be doing. I am a mere mediator.
Some people
There are two judgments which I can share with you after this session, wherein the Honorable High Court, the judges have imposed costs, and they have said it's okay. Now it is the discretion of each honorable judge. I do not want to get into that territory. That is not for me.
No, because to avoid the benches or avoid the another litigation, they will come to the mediation center.
Sir, we should be dispassionate when we deal with these matters. The file is before us. Once they do not want to mediate, then vapas kalsbeku. That's the end of the matter. We should not, yake, yenu anta now, we should not get into it. Because the more attached we get into all this, more troubled we'll be. There's no point.
Because now Mediation Act is there. Something you would have been preferred in this, whether they have given one teeth to, some type of teeth to bite the customers.
No, that's true, sir, but the Mediation Act has not been enforced in full. It has not come into force in full. Once it comes into force in full, I'm sure everything, there'll be a landmark change in the attitude of everybody.
Whether it is overrides section 89 of CPC?
Sir?
Whether it overrides the section 89 of CPC?
It doesn't override section 89, it goes hand in hand with section 89. In fact, because of section 89, the Mediation Act has come into force. But it has to be, all the sections have to be enforced as of now. It has not yet been notified in toto. Thank you,
Madam,
sir.
one thing is that they have not mentioned any remuneration about the mediators, because how can they claim the remuneration? Private parties, private mediators can claim anything about their will and this. In High Court mediations, in the Act they have not mentioned any about the remuneration. That's why, please.
Gottaglilla, sir. Sorry.
No, in this Act they have not mentioned any remuneration about the mediators. Mediator remuneration.
Oh, no, 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 that is not something that I can get into, sir. I am not a person in charge. Any other questions here, madam? We'll close? We'll close? Thank you. Thank you for this opportunity.
Thank you, madam.
Before they kick me out.
Good evening all. On behalf of Karnataka Mediation Center, I convey my heartfelt thanks to Srimati Vaishali Hegde, who has rendered a very enlightening speech on the topic, changing dimensions in the mediation field. I also convey my sincere thanks to Chairman of Karnataka Mediation Center, Board of Directors of Karnataka Mediation Center, Registrar of High Court of Karnataka, Bengaluru, Registrars of High Court of Karnataka, Kalburgi and Dharwad benches, Honorable Director of Karnataka Mediation Center, Honorable Deputy Director of Karnataka Mediation Center, Coordinators of Karnataka Mediation Center, Mediators of KMC, staff of KMC, and all other persons who have directly and indirectly helped us in organizing this CME. Thank you all.
Thank you.